Virginia gun owners, you have 11 days. The assault weapons ban signed by Governor Abigail Spanberger on May 14th, 2026 takes effect on July 1st, 2026. That is 11 days from today. And as of yesterday, June 19th, one of the first courts to rule on an emergency injunction request has denied that request. The clock is running. Multiple lawsuits are still pending. Other injunction hearings are still possible. But right now, as things stand today, Virginia's ban on AR-15S, AK pattern rifles, standard capacity magazines, and hundreds of other commonly owned firearms is on track to become enforceable law in less than 2 weeks. If you live in Virginia, if you own a gun shop in Virginia, if you are thinking about buying an AR-15 and you live in Virginia, or if you care about Second Amendment rights nationally, you need to understand exactly where this stands right now, today, June 20th, 2026. Subscribe right now, because this situation is changing daily, and I am going to be covering every development as it happens. Let me start with what the law actually does, because even many Virginians who know it exists don't fully understand what it bans and what it doesn't. Senate Bill 749 and House Bill 217, which are companion bills that accomplish the same thing, use what is called a feature-based definition to identify prohibited assault firearms. This means the law does not ban specific guns by name. Instead, it bans semi-automatic firearms that have a detachable magazine combined with any one of a list of prohibited features. This is an important distinction because it is broader than most people realize. You don't need multiple prohibited features. You need just one. Under the feature-based test, here is what gets captured as an assault firearm in Virginia starting July 1st. For semi-automatic centerfire rifles with detachable magazines, any one of the following features triggers the ban: a pistol grip that protrudes below the action of the weapon, a folding or telescoping stock, a thumbhole stock, a grenade launcher or flare launcher, a flash suppressor, a forward pistol grip, a barrel shroud that permits the shooter to hold the barrel area without being burned, or a threaded barrel capable of accepting a flash suppressor. You only need one. So a semi-automatic rifle with a detachable magazine and a standard pistol grip is an assault firearm under this law. A rifle with a detachable magazine and a telescoping stock is an assault firearm. Here is something that is catching gun owners and dealers completely off guard. A standard M-lock or Picatinny rail handguard on your rifle likely counts as a barrel shroud under this law. That means a perfectly ordinary AR-15 configured with modern rail furniture is captured by the ban, even if the owner removed the flash suppressor and the pistol grip stock. For semi-automatic pistols with detachable magazines, the prohibited features include a magazine that attaches to the pistol outside the pistol grip, a threaded barrel capable of accepting a barrel extender or flash suppressor, a shroud attached to or encircling the barrel, an unloaded weight of more than 50 ounces, or a second hand grip. For semi-automatic shotguns, the prohibited features include a folding or telescoping stock, a pistol grip that protrudes below the action, a fixed magazine capable of holding more than 5 rounds, and a detachable drum magazine. On top of the assault firearm definition, the law separately bans all ammunition-feeding devices capable of holding more than 15 rounds. This magazine ban is separate from the assault firearm definition and applies regardless of whether the firearm itself is banned. A standard capacity handgun magazine holding 17 rounds for a Glock 17, for example, falls under this ban even though the Glock 17 itself may or may not be an assault firearm depending on its other features. Now let me tell you what the law does not ban. Firearms that do not meet the feature-based definition are not affected. A semi-automatic rifle with a fixed stock, no pistol grip, no threaded barrel, and no barrel shroud is not an assault firearm under this law, even if it takes detachable magazines. Traditional hunting semi-automatic shotguns with fixed stocks and tube magazines are generally not captured. Governor Spanberger also pushed through an amendment exempting certain semi-automatic shotguns commonly used for hunting. And any firearms that you already lawfully owned and possessed before July 1st, 2026 can be retained under the grandfather clause. You do not have to surrender grandfathered firearms. You do not have to register them. You do not have to modify them. What the grandfather clause does not protect, and this is the part that infuriates gun rights advocates, is the market going forward. You cannot sell your grandfathered firearm to another Virginia civilian. You cannot transfer it. You cannot replace it if it is lost or stolen. And when you die, your heirs cannot take possession in Virginia. The market is permanently frozen. The penalties for violating the ban are a Class 1 misdemeanor, carrying up to 12 months in jail, a fine of up to $2,500, and crucially, a 3-year prohibition on possessing, purchasing, or transporting any firearm. That last penalty is the one that gun rights organizations say makes this ban particularly punitive. A first-time misdemeanor conviction for a single transaction puts you in the same legal position as someone on a temporary disarmament order. If you are finding this urgent and important, subscribe right now. The July 1st effective date is 11 days away, and the next court hearings that could pause this law are being scheduled right now. Subscribe so you are first to know the moment any court issues an injunction. Let me now walk you through the complete landscape of lawsuits that have been filed against this law. There are at least 6 active legal challenges, filed in both federal and state courts, using multiple different legal theories. Understanding the full picture matters because these cases may proceed on different timelines, and one successful injunction in any one of them could pause enforcement of the ban. Case 1. McDonald versus Katz. This is the federal lawsuit filed in the United States District Court for the Eastern District of Virginia, the Alexandria Division, on May 14, 2026, within minutes of Governor Spanberger's signature. The plaintiffs are the National Rifle Association, the Firearms Policy Coalition, the Second Amendment Foundation, and 2 private Virginia residents, Justin McDonald and Anthony Groneveld. The defendants include Virginia State Police Superintendent Colonel Jeffrey Katz and prosecutors from Goochland and Prince William counties. The legal theory is the federal Second Amendment under the Bruin framework. Common use equals constitutional protection. AR-15s are in common use. Therefore, they are protected. Therefore, Virginia cannot ban them. Here is something that was revealed about the strategy behind McDonald versus Katz that is critical for understanding the long game. The plaintiffs, represented by Cooper & Kirk, PLLC, one of the premier constitutional litigation firms in the country, actually admit in the complaint itself that they expect to lose at the lower federal level. Why? Because the Fourth Circuit Court of Appeals, which covers Virginia, has already issued decisions in cases called Bianchi versus Brown and Colby versus Hogan that upheld Maryland's assault weapons ban. Those decisions, issued before Bruin, may be precedent that the lower court is bound to follow, even if the reasoning no longer holds up under Bruin. Cooper & Kirk filed McDonald versus Katz, knowing they will likely lose at the district court and possibly at the Fourth Circuit level. But that is not the point. The point is to create a clean, well-developed federal record that can be taken directly to the United States Supreme Court via a petition for certiorari. They are intentionally fast-tracking this case to SCOTUS. Virginia is the vehicle they are using to finally force the Supreme Court to answer the question it has been avoiding since Bruin. Can states ban the most commonly owned category of rifle in America? Case 2, Black versus Hook. This was filed on May 15, 2026 in the Circuit Court of Fauquier County, Virginia. It was funded by the National Shooting Sports Foundation. The plaintiffs include 2 Virginia residents, Eric Black and Britton Condon, along with industry plaintiffs, Clark's Gun Shop operating as Clark Brothers, Optimus Arms LLC, and Hexmag USA LLC. The defendant is Scott C. Hook, the Commonwealth's attorney for Fauquier County. The Black versus Hook complaint argues that SB 749 violates both the United States Constitution and the Virginia Constitution. Critically, the plaintiffs in Black versus Hook filed an emergency motion for a preliminary injunction requesting a hearing by June 19th. That hearing was either held or scheduled as of this reporting. A preliminary injunction decision could come before July 1st. If granted, it pauses the law. Case 3, Crump versus Katz, filed by Gun Owners of America, Gun Owners Foundation, the Virginia Citizens Defense League, the Virginia Citizens Defense Foundation, and AmmoLand contributor John Crump in the Circuit Court for Lancaster County. This case also includes an emergency motion for a temporary restraining order and preliminary injunction to stop the law before July 1st. Case 4, Santola versus Katz, filed in the Circuit Court of Washington County, Virginia, by the NRA, the Virginia Shooting Sports Association, and several individual plaintiffs. This case argues that the ban violates Article 1, Section 13 of the Virginia Constitution, which is the state's right to keep and bear arms provision. The Washington County Court. Cases 5 and 6, Curtis versus Katz and Holloway versus Katz. These are the cases that brought the most recent news, Both were filed in the Circuit Court of Spotsylvania County by attorney Kenneth Cuccinelli, the former Attorney General of Virginia. These cases take a completely different legal approach from all the others. Rather than relying on the federal Second Amendment or the standard reading of the Virginia Constitution's right to arms provision, these cases focus on the Militia Clause of Article 1, Section 13 of the Virginia Constitution. The Militia Clause protects arms that are necessary for the citizens to fulfill their role in a well-regulated militia. The argument is that AR-15 style rifles are precisely the weapons that citizens would use as militia members and therefore cannot be banned under this specific constitutional provision. Hey, 73% of people watching right now are not subscribed. If you are a Virginia gun owner or you care about Second Amendment rights in your state, this is the single most important legal fight happening in America right now, and I am covering every development in real time. Hit subscribe right now. Now let me tell you what happened yesterday, June 19, 2026. A Spotsylvania County Circuit Court judge heard argument in the Curtis v. Katz case and ruled against the plaintiffs. The judge denied the preliminary injunction in the Militia Clause challenge. And how the judge reached that conclusion has gun rights advocates furious, not just because they lost, but because of the method the judge used. The judge applied interest balancing. He weighed the public safety interest of the government against the harm to the plaintiffs, and concluded that the public safety interest outweighs the harm. The problem with that reasoning is that the United States Supreme Court in Bruin specifically and explicitly rejected interest balancing as the correct test for Second Amendment cases. The court said courts are not supposed to weigh constitutional rights against government interests. That approach was the pre-Bruin method. After Bruin, it is historical tradition or nothing. The judge in Curtis v. Katz essentially applied the test the Supreme Court abolished. Gun rights attorneys are already describing this ruling as a clear Bruin violation. Kenneth Cuccinelli held a press conference on June 19th following the ruling. He made clear that his team is now weighing whether to appeal. They have 15 days from the ruling to file a notice of appeal. Cuccinelli called the decision troubling not just for this case, but for the future of Virginia gun rights because the court essentially ruled that Virginia can ban any arm it wants as long as it cites public safety. That is precisely the reasoning Bruin was supposed to end. Whether to appeal and how quickly to do so is now the central question for the Cuccinelli team. There is one more development from the Spotsylvania case that deserves to be highlighted because it is genuinely remarkable. The Commonwealth's attorney for Spotsylvania County, Ryan Mahaffey, is listed as a defendant in Curtis v. Katz because he is the local prosecutor. But Mahaffey filed a brief in the case arguing that the plaintiffs should win and the injunction should be granted. He filed a brief arguing against his own side, explaining that as the Commonwealth's attorney, he has a constitutional duty that he believes prohibits him from enforcing an unconstitutional law. Mahaffey has publicly stated he will not enforce the assault weapons ban. He is not alone. Multiple Virginia prosecutors across the state have gone on record saying they will not enforce SB 749. This is an extraordinary situation. A law is about to take effect in Virginia, and some of the people whose job it is to enforce it have announced in advance that they will not. The practical significance of this cannot be overstated. In counties where the Commonwealth's attorney refuses to enforce the ban, residents may face very different practical outcomes than residents in counties where prosecutors plan to enforce it aggressively. Let me now turn to the question of what happens if no court issues an injunction before July 1st, because as of this moment, with 11 days left, no injunction has been granted. The Militia Clause challenge just lost. The other cases are still pending. And the July 1st clock does not stop. If July 1st arrives without an injunction, Virginia gun dealers who have been selling AR-15s, AK pattern rifles, and any other firearms captured by the feature definition must stop those sales. They cannot complete transfers. They cannot accept new consumer orders for in-state delivery of banned items. Dealers who already have customers waiting for banned items that have been ordered but not yet transferred face a difficult choice. Those transfers cannot legally be completed after July 1st. Virginia joins a short list of states currently including California, Maryland, New York, New Jersey, Connecticut, Massachusetts, Illinois, Hawaii, Colorado, Rhode Island, and now Virginia, with active assault weapons bans. With SB 749's enactment, Virginia becomes the 12th state in this category. For consumers, if you are a Virginia resident who has been thinking about purchasing an AR-15 or any modern sporting rifle, or any magazine holding more than 15 rounds, and you want to have that firearm or magazine grandfathered, the deadline is June 30th, 2026. The purchase must be completed, and the transfer must happen before July 1st. After July 1st, if no court has issued an injunction, you cannot legally purchase, import, or receive those items in Virginia. 11 days. This is not a rumor. This is not something that might happen. This is the law as signed by the governor, taking effect on July 1st, with no court order currently stopping it. Here is where things get complicated regarding the Fourth Circuit. As I mentioned earlier, the Fourth Circuit has precedents upholding Maryland's assault weapons ban in the Bianchi and Colby decisions. The Eastern District of Virginia is in the Fourth Circuit. Any federal judge in that district is supposed to follow Fourth Circuit precedent. That means McDonald versus Katz faces a difficult path at the district court level. The lower court may feel bound to uphold the ban based on those precedents, even if the judge personally believes Bruin changes the analysis. And at the Fourth Circuit level itself, the court would have to confront whether Bruin has undermined its own prior decisions. That is not a simple question, and Fourth Circuit panels don't always reach the same answer. The state court cases have a different path. Virginia state courts interpreting the Virginia Constitution are not bound by the Fourth Circuit's interpretation of the federal Second Amendment. Virginia's Article 1, Section 13 is a separate provision that Virginia courts interpret independently. The state constitutional challenges may actually have a faster path to meaningful relief than the federal challenge, even though the federal challenge is the one that will ultimately go to SCOTUS. Now let me talk about what the Cooper and Kirk strategy means for the national picture. The attorneys behind McDonald versus Katz have been among the most effective Second Amendment litigators in the country for years. They have thought carefully about how to use Virginia's ban to get a definitive Supreme Court answer on assault weapons bans. Here is why Virginia is a particularly good vehicle for this strategy. The Fourth Circuit's existing precedents upholding Maryland's ban make it almost certain that McDonald versus Katz will lose at the lower levels. A loss at the Fourth Circuit creates a situation where plaintiffs can petition the Supreme Court saying, "Look, the Fourth Circuit is still following pre-Bruin reasoning to uphold an assault weapons ban. The Seventh Circuit is sitting on a case about Illinois' similar ban. The Ninth Circuit has upheld California's ban." Every circuit that has addressed this issue has upheld assault weapons bans using reasoning that Bruin was supposed to end. The Supreme Court has to step in and resolve this. Cooper and Kirk are engineering a SCOTUS grant. At the Supreme Court, the composition of the court matters enormously. As has been reported, Justices Kavanaugh, Thomas, Alito, and Gorsuch have all indicated strong interest in the constitutionality of assault weapons bans. Kavanaugh dissented from a D.C. Circuit decision upholding D.C.'s assault weapons ban back in 2011, long before Bruin. Thomas has written extensively about the importance of protecting commonly owned firearms. Alito and Gorsuch joined the Bruin majority and the Heller majority before it. If any one of those four can bring a fifth justice to their position, the Supreme Court strikes down assault weapons bans nationwide. The question is whether Roberts, Sotomayor, Kagan, or Barrett will be that fifth vote. Let me also address the DOJ's expected involvement in this litigation. Harmeet Dillon, the Assistant Attorney General for Civil Rights, publicly stated that the DOJ would file its own lawsuit against Virginia's ban. The Trump DOJ has already sued Colorado and the District of Columbia for similar bans. A federal government lawsuit against Virginia's ban would be extraordinary. The DOJ suing a state for enacting gun control puts the full weight of the executive branch on the side of gun rights in Virginia. If and when that lawsuit is filed, it changes the political and legal landscape dramatically. As of this recording, the DOJ lawsuit has not yet been filed, but Dillon's public statement makes clear the intention to file. When it is filed, I will cover it immediately. Subscribe so you don't miss it. Let me give Virginia gun owners a clear and specific action plan right now. There are several things you can do in the next 11 days and in the weeks and months that follow, depending on what the courts decide. First, and most urgently, if you want to own an AR-15 or any firearm or magazine that will be banned after July 1st, the time to make that purchase is now. You have 11 days. Find a licensed dealer, complete your background check, and take possession before the deadline. Any firearm or magazine that you lawfully own and possess before July 1st is grandfathered. You can keep it. But after July 1st, you cannot buy a replacement. Second, document your existing grandfathered collection. If you already own firearms or magazines that would be banned under SB 749, create a written record today. Date of purchase. Method of purchase. Keep any receipts, transfer records, or other documentation that shows you acquired these items before July 1st. This documentation proves your grandfather status if questions ever arise. Third, understand the geographic variation in enforcement. Some Virginia Commonwealth's attorneys have publicly stated they will not enforce SB 749. Know whether your local prosecutor is in that category. This does not make the law legal or constitutional. It does not mean you have a legal right to violate it. But it is a practical reality about enforcement that varies by jurisdiction. Fourth, follow all 6 lawsuits closely. The state court cases in Fauquier County, Lancaster County, Washington County, and Spotsylvania County all have hearings scheduled or upcoming. Any one of them could produce an injunction before July 1st. Fifth, support the litigation organizations that are fighting this in court. The NRA, FPC, SAF, GOA, VCDL, and NSSF are all spending significant resources on these cases. They need financial support. Sixth, if you are a dealer or FFL in Virginia, you need compliance guidance now. Contact your legal counsel about which items in your inventory fall under the assault firearm definition and what you must do before July 1st. Pay particular attention to modern sporting rifles and pistols, MSR pattern pistols, and standard capacity magazines. Seventh, do not take matters into your own hands. Do not rely on the fact that your local prosecutor has said they won't enforce the law as grounds to violate it. The state police can still arrest. A new prosecutor could be elected or appointed, and federal authorities could potentially get involved in some circumstances. Follow the law as it exists until a court says otherwise. Let me address one more thing that is important for gun owners outside Virginia. This fight matters to you too. The legal precedents being set in Virginia will be cited in assault weapons ban challenges in every other state. The Cooper and Kirk strategy is explicitly designed to create a Supreme Court vehicle that resolves the assault weapons ban question for all 50 states at once. If McDonald v. Katz makes it to SCOTUS and the court rules that commonly owned semi-automatic rifles cannot be banned, every assault weapons ban in America falls. California's ban, Maryland's ban, Illinois's ban, New York's ban, Connecticut's ban, Massachusetts's ban, all of them, gone in a single Supreme Court decision. This is why gun rights groups around the country are watching Virginia with such intensity. This is not just Virginia's fight. This is the fight for the future of the Second Amendment in America. Virginia is the 12th state to ban assault weapons. It may be the state that ends all assault weapons bans. The irony of that is not lost on anyone who has been following Second Amendment litigation since Bruin. 11 days to July 1st. The courts are moving. The lawsuits are active. The militia clause challenge just lost. Other injunctions are still possible. And if no court acts in time, Virginia gun owners will live under this law while the legal fight continues in the courts for months or years. That is the reality right now, and you need to stay informed about every development. Subscribe to this channel now because I will have every court ruling, every injunction decision, and every major development covered the moment it happens. The July 1st deadline is 11 days away. Do not wait to stay informed. Subscribe right now. And please remember, this is educational content only. It is not legal advice. For your specific situation, especially if you are a dealer, a gun owner with questions about specific firearms, or someone facing compliance questions, consult a qualified firearms attorney licensed in Virginia. The law is changing fast, and you need current, accurate legal guidance for your individual circumstances.